Hello everyone, my name is Hannah Riley and today I'll be going over private placement, due diligence, term sheets, and regulations. Private placement memorandums serve as a security document when conducting business for an investor who desires to sell their shares. They are legal documents that explain who is selling the securities, who is buying, the basic investment risk, terms and conditions of the investment, and any other specific details. Business plans are similar to PPMs, however, private placement memorandums are not persuasive and they simply help investors establish good judgment about the constitutes of the investment. In order for a private placement memorandum to be drafted correctly, it must contain disclosure requirements that are suitably balanced and allow for a quick and easy deal. A private placement offering is an offering that does not need to be registered with the SEC and that is the share that is issued by a smaller business in order to increase their capital. PPOs are considered one of the most feasible tactics when considering capital formation alternatives because commercial bankers and venture capitalist standards have several restrictions. One advantage to PPOs is that they have the ability to reduce transactional and constant costs because of the exemption from many of the wide-ranging federal and state reporting and registration requirements. A term sheet is a non-binding agreement setting forth the basic terms and conditions under which an investment will be made. They are most often associated with startups. Entrepreneurs find that the document is crucial to attracting venture capitalists with the available capital to fund their enterprises. The valuation of the stock, amount of investment, the percentage of stake sought, voting rights, liquidation preferences, anti-dilutive provisions, and investor commitment are some of the main key terms that should be spelled out in term sheets. Due diligence is an exercise a potential investor should take before entering into a permanent agreement or contract. It refers to the research taken before a financial transaction with another company. A seller can perform due diligence on a buyer by making sure that the buyer has an adequate amount of resources to fulfill the transaction. Also, individuals are highly recommended to perform due diligence on a security, but brokers, dealers are obligated to perform due diligence before they sell security to an individual. This will ultimately prevent them from holding liability when there are non-disclosures of significant information found during the investigation. Next, we have regulations. The Securities Act of 1933 requires businesses to file a registration statement with the SEC before they decide to sell a security in interstate commerce. Section 4.2 allows for an exemption from registering for transactions by an issuer not involving a public offering. And Section 3A complies with the private placement requirements and provides an exemption from registration for any security which is part of an issue offered and sold only to persons resident with a single state by an issuer which is resident and doing business within that state. And lastly, Regulation D lets companies doing certain private placements raise capital without needing to register the securities within the SEC. The company or entrepreneur must still file the Form D disclosure document with the SEC after the first securities are sold. Those selling under Regulation D must still comply with the applicable state laws covering the offer and sale of those securities. Regulation D exemptions only apply for the transactions, not to the securities themselves.